to meeting number 2 of the House of Commons Standing Committee on Justice and Human Rights. Today's meeting is taking place in a hybrid format, as we can see, pursuant to the House Order of September 23rd, 2020. The proceedings will be made public, will be made available via the House of Commons website. Just so that you're all aware, the webcast will always show the person that is speaking rather than the whole committee room. Before we go into clause by clause consideration of Bill C3, which is on the agenda today, let's first adopt the subcommittee report from the meeting last Tuesday. So I ask you for support on adopting the meeting minutes, which have been circulated to you. Just by a show of hands. Okay, adopted. So this Thursday, we are receiving the Minister for main estimates. Last week, the committee received the order of reference for the examination of supply estimates B. So I would ask if it's the will of the committee to also do the subs at the same time this Thursday, or would you like to do it at a separate time? And I open it up for any addressing this at all. So would the committee then be okay to have the subs to be brought forward to the minister at the same time as the mains for the Thursday meeting? Can I see a thumbs up from everybody in agreement? Good. Okay. So Mr. Clerk and the analyst, if we can just amend the briefing books so that they include the subs as well, please, that would be great. Thank you. So the in our last meeting, Mr. Garrison had a question at our first meeting whether or not the WIP's office staff and member staff could have access to our Zoom virtual room with camera and mic off for public meetings. So we're happy to report that a pilot project is currently going on, allowing the WIPs and House Leaders office staff to attend in that manner with their mics muted and their videos off. We are looking into extending that possibility to member staff as well. So pursuant to the order of reference on Monday, October 19th, 2020, the committee is meeting today for the clause-by-clause consideration of Bill C3, an act to amend the Judges Act and the Criminal Code. We are joined today by video conference by officials from the Department of Justice. We have Stefan Zalewski, who is the General Counsel and Director of the Judicial Affairs Section. We have Adair Crosby, General Counsel, Judicial Affairs Section, and Jillian Blackwell, a Senior Counsel and Team Lead at the Criminal Law Policy Section. So you will be able to ask the officials questions through me if you have any questions around what we're doing today with the clause by clause, just to clarify any issues that arise. So to ensure an orderly meeting, I'd like to outline a few rules that we should be following. Members and witnesses may speak in your official language of your choice. Interpretation services are available for this meeting. You have the choice at the bottom of your screen of either floor, English, or French. So you can pick whatever interpretation you would like to hear. For members participating in person, proceed as you usually would when the whole committee is meeting in person in a committee room. Keep in mind the directives from the Board of Internal Economy regarding wearing your mask and health protocols. I see that we do have at least one member that's in the house today in the committee room. So before speaking, please wait until I recognize you by name. For those participating virtually, please click on the microphone icon to unmute yourself. Those in the room, your microphone will be controlled as normal by the proceedings and verification officer that's there. A reminder that all comments by members and witnesses should be addressed through the chair. When speaking, speak slowly and clearly, and just note that there is a bit of lag with the interpretation. So when you end a sentence, just give it a few seconds before carrying on in another language, or before the next speaker speaks, just to allow the interpreters to finish speaking. When you're not speaking, I would ask that your microphones please be on mute, so that we're not disrupting anybody else who's speaking. With regard to speaking list, the committee clerk and I will be doing our best to maintain a consolidated order of speaking for all members, whether they're participating virtually or in person. And I know that when you're participating virtually, if you can use the blue raise hand function on your participants through your participants list, I would be able to recognize the members that are in the room. Just flag to the clerk, and the clerk will let me know if you would like to be put on the speakers list, and we'll do so accordingly. Are there any questions at this time from anybody? Okay. I'd like to provide members of the committee with some instructions and a few comments on how the committee will proceed with the first clause-by-clause consideration during of a bill in a hybrid meeting format. So this is the first time we're doing this. I'll be going as slowly and as cautiously as possible. We obviously don't want to inadvertently do something that we may have difficulty taking back later on. Hopefully this will go smoothly with the help of all of these wonderful supports that we have here today. So as the name indicates, this is an examination of all clauses in the order in which they appear in the bill. I will call each clause successively, and each clause is subject to debate and a vote. If there are amendments to the clause in question, I will recognize the member who's proposing it, who may explain or speak to the amendment that they've submitted. The amendment then will be open for debate. When no further members wish to intervene, the amendment will be voted on. Amendments will be considered in the order in which they appear in the bill or in the package that each member has received from the clerk. If there are amendments that are consequential to each other, and I will identify them as we get to them, they will be voted on together. Pursuant to the House Order of September 23rd, 2020, all questions shall be decided by a recorded vote, except those that are decided unanimously or on division. And so in addition to having to be properly drafted in a legal sense, amendments must also be procedurally admissible. The chair, so I may be called on to rule on amendments if you feel that are not admissible, or if they go against the principle of the bill or beyond the scope of the bill, both of which were adopted by the House when it was agreed to the bill as second reading, or if they offend the financial prerogative of the Crown. If you wish to eliminate a clause of the bill altogether, the proper course of action is to vote against that clause when the time comes, not to propose an amendment to delete it. Since this is the first clause-by-clause consideration of a bill in a hybrid meeting format, I will go slowly to allow all members to follow the proceedings properly. If during the process the committee decides not to vote on a clause, that clause can be put aside by the committee so we can revisit it at a later time in the process. The amendments have been given an alphanumeric number that's on the top right corner of the package that has been given to you to indicate which party submitted them. There's no need for a seconder to move an amendment. Once moved, you will need unanimous consent to withdraw the amendment. So during debate on an amendment, members are permitted to move sub-amendments. These sub-amendments must be submitted in writing or by email for members participating virtually. They do not require the approval of the mover or the mover of the amendment. Only one sub-amendment may be considered at a time, and that sub-amendment cannot be amended when a sub-amendment is moved on an amendment. It has to be voted on first. Then another sub-amendment may be moved, or the committee may consider the main amendment and vote on it. Once every clause has been voted on, the committee will vote on the title and the bill itself, and an order to reprint the bill may be required if amendments are adopted, so that the House has a proper copy of for use at report stage. Finally, the committee will have to order the chair to report the bill to the House. That report contains only the text of any adopted amendments, as well as an indication of any deleted clauses. I thank the members for their attention and wish everyone a very productive clause by clause. If there are any questions at this time, you can raise them now.
Oui, Madame la Présidente.
Yes, go ahead, Monsieur Fortin.
Madam Chair. Madam Chair. Yes, can you hear me? A few moments ago, you talked about the package of amendments. I didn't receive that, or perhaps I didn't understand. Could you re-explain what you meant by that? What I have is a document from this morning.
If you just show me that. No, so the clerk would have sent you a package of the amendments. There were 9 in total that were submitted by various parties.
Est-ce que vous pouvez me dire à quel moment?
When were those sent? I didn't receive them.
If you want to, please speak to that, when they were sent. Sorry, I don't have the date on hand.
Madame la Présidente, ça a été envoyé vendredi dernier.
They were sent out last Friday, but I'll try to send them right to Mr. Fortin right away again. Thank you.
Just bear with us. We'll resend them to you very shortly.
No, c'est okay.
No, I've got them. I just found it. I did receive it on Friday. I apologize. That's my mistake. Sorry.
Okay. Wonderful. Thank you very much for clarifying that, Mr. Fortin. And just a reminder, if there are amendments to be moved to the floor, please have them ready in writing so that we can circulate them to all members at the time that we're going to debate them, so that we all know concretely what it is that we're speaking to. So going right into the clause by clause, if there are no other questions. Okay, we'll start with clause 1 of the bill. So clause 1, I see that there is an amendment that has been proposed by Lib 1 by Mr. Fergus. Mr. Fergus, if you would like to speak to that amendment that you're proposing.
Merci beaucoup, Madame la Présidente. Puis,
Yes, thank you, Madam Chair, and welcome to colleagues this morning.
Stop you right there for a second. I see the legislative clerk has their hand up. Is it with respect to anything that we've spoken about before?
Yes, it's just that before going to clause 1, we should mention that the preamble will be postponed.
Yes, thank you for reminding us of that. So when we go into clause by clause, the preamble will be discussed at the very end. So we'll start with clause 1, 2, 3, 4, and then we'll be going into the preamble before we vote on the title and the bill itself as amended.
Madam Chair.
Yes, Mr. Maloney.
Does that mean that the preamble is capable of being amended once we've completed our clause by clause?
Yes. So the only portion of the bill that is not able to be amended is the summary. Please correct me if I'm wrong on this. But my understanding is that the only portion that cannot be amended is the summary of the bill. So preambles are open for amendment also after we've gone through all of the clause by clause.
And can the clerk confirm your interpretation
Mr.
with
Clerk,
respect to the summary?
Mr. Clerk, if you want to speak to that, please.
Yes, that's correct. The preamble can be amended at the end if there are substantive amendment to the bill.
And what about the summary?
Specifically the summary?
The summary, no, the summary can't be amended.
Okay.
Does that clarify for you, Mr. Maloney?
It does. Thank you very much.
Thank you. So I will go back to
Madame la Présidente?
yes, Monsieur Fortin.
Oui, Madame la Présidente.
Yes, Madam Chair. I had a discussion this morning with my Liberal colleague, Mr. Arif Virani, and there are some amendments that I want to propose. I believe that Mr. Virani circulated the document, but I'm not mistaken. If could you let me know if that's happened, or should I be sending it out, or could perhaps Arif could clarify that if it's been sent out?
Thank you, Monsieur Fortin. So now these amendments, I will ask that you, Monsieur Fortin, if you can circulate them to all of the members of the committee, as well as the analysts and the clerk, so that we have them ready, so that when we come to that specific section in the bill, we will turn to you then and make sure that everybody has it in writing in front of them when you speak to them. Now, are these amendments starting from clause 1? I don't think so. I think your first one comes from clause 2.
Oui, l'article 2 qui amende l'article 3 de la loi.
Yes, clause 2, amending section 3 of the Act. So you want me to send that to everyone then? I don't have everyone's address here. Perhaps I could send it to the clerk, or...
If you can send it to the clerk, and Mr. Clerk, if you can circulate that to everybody, that would be great. And so when we come to your specific amendment, Monsieur Fortin, then we'll come to you. But right now we're on the first clause, and we have to go down clause by clause by clause. My understanding is that none of your amendments seek to amend any part of clause 1. So we will come to you once we have your once we come to that part that you're trying to amend. Is that okay? Is that okay, Mr.
Oui,
Fortin?
là, je suis en train de chercher. Un instant. C'est parce que là, avec...
Well, just a second here, just a second. It's getting a bit complicated to try and manage all of this. So I'm looking for the clerk's email address, first of all. So if someone's got it, otherwise I'll keep looking, but...
Ask you to send an email to Monsieur Fortin's P9 so that in reply to it, he can just attach whatever documents that he needs to send to you.
Yes, I will do that, Madam Chair. Thank you.
Thank you. Monsieur Fortin, the clerk will send you an email very shortly.
Merci.
Okay. Is there anything else, Monsieur Fortin, that you're having challenges with at this time?
Non, je vais vous en...
No, it's all good. I'll send you the document here. I'm trying to work with the interpretation as well, and it's excellent. Well, I assume it is because I can't hear the other language, but it causes a delay all the time because of the lag. And it's nobody's fault. It's something I've got to get accustomed to, the lag caused by interpretation. So,
thank you. Thank you, Monsieur Fortin. So we'll go back to Mr. Fergus to speak to Lib 1, which amends Clause 1. Go ahead, Mr. Fergus.
Et merci beaucoup, Madame la Présidente.
Well, thank you, Madam Chair. And to Mr. Fortin, French is never an inconvenience. First of all, I'd like to thank everyone for this opportunity to to be here, because as you know, I'm not a member of the committee, a regular member. Bill C3 is something that I'm very interested in, concerned about as a member of Parliament, and I'm also the chair of the Black Caucus. The work that you're doing in order to raise the awareness of the legal system to the reality is laudable, essential, and I support the bill in its entirety. However, I also found that this offered us an opportunity to deepen some of the notions and include some additional groups into the purpose of the bill. And so that's why, as you can see through my amendment, I'm proposing an amendment, a change, to include the social context, which it addresses racism, systemic discrimination as well. And I hope that you will support my amendment because I believe that it is general in scope and it covers groups facing discrimination, but it's also specific enough to indicate what we're addressing here. So that is my justification for the amendment, and I'll be moving another one a bit later on as well.
Thank you, Mr. Fergus. And just for clarity, Lib 1 will be amending the bill on page 2, line 22, by adding the language social context, which includes systemic racism and systemic discrimination, including by attending seminars established. And so I'm going to go now to the speakers list for those members that would like to speak to it. I see Mr. Virani, you're next on the speakers list. You're on mute, Mr. Virani.
I apologize. I changed my language, but not taking off the mute button. Thank you, Madam Chair. I just want to speak in support of Mr. Fergus's suggested amendment. I think this amendment reflects the importance of tackling these issues as part of the judicial training that is being recommended to the judges via this bill. I think it reflects sort of where we are as a nation, as a continent, and I think you can see the importance of it given that similar amendments were proposed by 3 different parties that are participating in today's session. So clearly parliamentarians are fixated on ensuring that there's no ambiguity in terms of the necessity of addressing racism and discrimination and its systemic aspects in the context of looking at what social context is meant to mean in terms of the way it is used in this bill. So just wanted to echo my support for what Mr. Fergus is suggesting here. Thank you.
Thank you, Mr. Virani. Does anybody else want to speak? Oh, Monsieur Fortin, I see your hand raised.
Oui.
Yes. Well, first of all, I welcome the amendment put forth by Mr. Fergus and indicate that the social context, as it says, which includes systemic racism, but I have a problem with the word systemic. Now, I realize that that's a very popular word these days, but not everyone necessarily agrees with what systemic racism means. I think it might be more judicious to leave racism and discrimination in the wording in the text without the word systemic. Well, I don't want to launch into a debate on how it might be interpreted, because it's a subject that's being discussed in Quebec, in the Chamber, etc. But I think that we should avoid falling into the trap here, and we should remove the word systemic and keep racism and discrimination, because racism is described in the Charter. So to my mind, I believe that it stands on its own.
Thank you, Monsieur Fortin. Mr. Fergus, I see your hand raised next.
Oui, et puis je remercie.
Yes, and I'd like to thank Mr. Fortin for his support for the objective of the amendment. I don't want to get bogged down in details here either, but it seems to me that there is a broad consensus developing around the usage of the word systemic racism and systemic discrimination. It's a bit broader, it's a bit broader than simply talking about racism and discrimination. But as I said, there is consensus. Not unanimous, but there is consensus developing around the definition of systemic racism and systemic discrimination. So I would like to maintain it in the amendment. Thank you, Madam Chair.
Que je comprends que son...
Please raise your hands. I thank you. I appreciate that.
Je voulais juste
Mr.
un
Moore?
éclaircissement de la part de monsieur.
I just wanted some clarification from Mr. Fergus on.
Just raise your hand and we'll come back to you. I have Mr. Moore and then Mr. McGregor.
Thank you, Madam Chair. Yeah, the raised hand function will serve us all well, so we don't have a free-for-all. But, you know, this discussion brings me to a point. I'm questioning, and maybe some of the other members can answer from the other parties. We have a bill with this bill that this is our third try at it. The bill passed through the House. It's in our committee. It has the support of all parties, I believe. But then we see this flurry on Friday of amendments, and there's some questions being raised about the amendments. I'm sure there's questions about each one of those amendments that, you know, be interesting to hear from experts on what the impact of each amendment. We've studied Bill C3 in its current format a couple times, but these amendments, it was the wish of the other parties to not have any more witnesses. So there's no expert to speak to the amendments that are being proposed. I think that is a shame as a committee that we're proposing amendments that we haven't heard testimony on the specifics of the amendments. And that's not how, in my view, we do our jobs as legislators. We want to get the bill right. So to propose a flurry of amendments without having heard testimony that's relevant and could speak to the specifics, I think that's leading us down the wrong path. So this is an interesting discussion, but it would have been nice to hear some witnesses that could speak to these amendments, which we.
Thank you, Mr. Moore. I have Mr. McGregor, then Monsieur Fortin, then Arif Virani. Go ahead, Mr. McGregor.
Yes, thank you, Chair, and hello to everyone. Good to see all of your faces again. I guess I'm going to be supporting Mr. Fergus's amendment, and I'll maybe just address Mr. Fortin's concerns first. I just did a quick word search of the word systemic in witness testimony. The word systemic is used multiple times from the witnesses that appeared before our committee when this bill was being studied in the first session. I think it's widely understood that this country does have a systemic problem when it comes to discrimination and racism. It's not a term I have problems understanding, and I'm sitting here as a white male. So I think it's broadly understood and it's important to have there. Secondly, to Mr. Moore's points, I would also draw his attention to witness testimony from the first session. There were a number of witnesses who did, in fact, tell our committee that the fact that social context was not defined was problematic. And so I think, we could go through a laundry list of what social context means, but I think Mr. Fergus has done it correctly by using these terms, by using the terms systemic racism and systemic discrimination, because I think those two terms are broad enough to encompass a lot of the discrimination factors that people of color, people of different sexual identities face on an everyday basis. And we would be kidding ourselves if we thought those weren't tied up to sexual assault and the problems that many women and many people of different backgrounds face on a daily basis with our justice system. So I would just say on the two objections that have been raised, they are in fact addressed by witness testimony that this committee has already heard, and I think they are broadly supportive of the amendments put forward by Mr. Fergus. Thank you.
Thank you, Mr. McGregor. I have Monsieur Fortin. You're next on the list. You're on mute, Mr. Fortin.
Merci.
Thank you. I had put my hand up, but so I was wondering, I didn't understand exactly what he said he wanted, what he meant at the end of his remarks with respect to the amendment. I thought that he said that he agreed with removing the word systemic. Did I misunderstand that? Oh, I did. I misunderstood that. Okay, well then I will reiterate then. Well, witnesses have talked about it. People across Quebec are talking about it. People are using the word systemic because it's popular now. But having said that, we're drafting legislation here. So we're saying that judges will be required to take a training that undertakes to participate in continuing education on matters related to sexual assault, the law, and social context. And here he's saying, which includes systemic racism and systemic discrimination. Now, to my mind, we don't want to force judges to take training on the concept of systemic discrimination. Perhaps for parliamentarians, when they're adopting legislation, it's up to us to look at whether that exists in our organizations. But for the judge who's interpreting the text of law, well, he needs to be aware of what discrimination and racism are. That's a good thing to my mind. But including the notion of systemic, well, that's quite vague. There isn't a full consensus. Well, he said there's not unanimous, but there is some consensus, a broad consensus out there. But I think that unless it's crystal clear, then as legislators, we should avoid introducing into legislation a word that we know at committee isn't clear and that will eventually lead to trials. There'll always be someone saying, well, no, that's not what that means. So it seems to me that what we want here is for judges to be trained on racism and discrimination. Okay, well, let's say that. But let's not add any unclear words that may lead to problems when it comes to interpreting the legislation.
Thank you, Monsieur Fortin. Mr. Virani?
So just a couple of points. So in response to what Monsieur Fortin is raising, I would simply state that the notion of systemic is actually quite critical, and it's a term that's being used appropriately right now by many elected representatives and other individuals. And I would just actually commend everyone's consideration of the way that Senator Murray Sinclair put it in the last Parliament when we were studying religious discrimination and systemic racism in the Heritage Committee. And he said, systemic racism is what you have once you've gotten rid of all of the racists. And that's a very elegant way of talking about the fact that there's something very different from an individual act motivated by an individual who's malintended versus rules, norms that pervade institutions. And I'll give a tangible example to everyone because it went right through this Justice Committee. When we make a change to peremptory challenges of jurors, which are challenges so that you can just look at the juror and say, well, I don't want that person on the jury without having to motivate why, you actually enabled a form of racism in the justice system that was systemic. By eliminating that in last Parliament's Bill C-75, we tackled a manifestation of systemic racism. So I do think it's very, very critical, and I would echo the comments you heard from Mr. Fergus and from Mr. McGregor. And with respect to Mr. Moore's point, I think it's our role to hear the witness testimony and then to gather from it and glean from it proposed amendments, which is exactly what we've done here. And the term systemic and systemic discrimination was used on a number of occasions by a number of witnesses, and thus the formulation of the amendment that you see before you. Thank you very much.
Thanks, Mr. Virani. Mr. Fergus, you're next.
Thank you, Madam Chair. And I hope that we were able to clarify my comments to Monsieur Fortin. I did not wish to give the impression that I didn't feel that that I'd be willing to move off of the word systemic. No, I think it's a very important word, and for the reasons that Mr. Virani had just pointed out. Secondly, just because there is a large consensus doesn't mean that it's unanimous, but there is a large consensus, I think, across the country as to the use and to the meaning of the word systemic racism or systemic discrimination. I liked what Mr. Virani had pointed out by pointing out what Senator Sinclair had raised as an example. I would offer another example. Studies have shown that Blacks or Indigenous peoples are no more likely to commit a crime under all factors kept the same as non-Indigenous or non-Black people. Yet, when you take a look at our incarceration populations, you will find that for Black Canadians, they're 3 to 4 times more overrepresented in our incarceral system than non-Black Canadians. For Indigenous peoples, it's worse. It's 7 to 8 times their demographic weight. So we know, or we strongly suspect, that there are no racists who are, who are administering justice throughout the entire system, even including judges. But yet there is something that's going on that's leading to these wonky results. That is the systemic nature of discrimination and of racism at work. It's so these are the things that force us to ask these uncomfortable questions. And by including this in the training, we are just heightening people's awareness of it so they can see the things that we can get at the things that they really can't normally see. That's the insidious nature of systemic issues. So I hope with those examples that we could move on and I hope achieve a consensus around this table that these are important elements to include in this bill. Thank you.
Thanks, Mr. Fergus. I have Mr. Maloney next on the list.
Thank you, Madam Chair. Look, I support the amendment as well for the reasons that have been outlined by others, Mr. Fergus in particular. As for Mr. Moore's concerns, I mean, there was evidence heard by the committee back in February. This isn't identical to the bill that was debated and passed by the House last year. You're quite correct. But the evidence we heard in February, I do not believe was available last year. And circumstances have changed. My understanding is that there's almost universal support for this language in this bill beyond this committee. So I'm quite comfortable for that. I respect your concerns, but I'm comfortable with the amendment that it doesn't cause any difficulty because of that. As for Mr. Fortin's comments about using the word systemic, his point was this may be crossing a line because we're telling judges or signaling to judges, perhaps is a better way of putting it, what they should be thinking and doing. I think that argument is sort of more universally applied to this bill, but we've crossed that threshold, Mr. Fortin, and I think the use of the word systemic does not cause any difficulty. It's not in any way indicating to judges, and nor will judges interpret it as instructionary, if I can use that word. In fact, I think people who are troubled by the suggestion that there is systemic racism should not be worried, because this will, I think, in the context of the courses that take, the pros and cons of all these arguments will be fleshed out. So for that reason, I think it's a good move to include it in the amendment. And as I said, I am supporting it. So thank you, Madam Chair.
Thank you, Mr. Maloney. I have 3 more people on the speakers list before I call the question on the amendment that is Lib 1. So Mr. Batiste, then Monsieur Fortin, and Mr. Moore. So go ahead, Mr. Batiste.
Thank you very much. And as an Indigenous person who's coming to you from Indigenous community. I really do support MP Fergus's wording around this. I do not feel that systemic racism is a popular term that we're using because it's popular recently. I believe it's an acknowledgement of what's going on in society and the acknowledgement of and a realization that things need to be done. And I think that from judges' perspectives, 3 years ago, I was the treaty education lead for Nova Scotia and was invited actually by all of the Atlantic federal judges to give a 1-hour presentation on reconciliation. And so these are things that judges are currently doing now, but this is what I think MP Fergus is doing gives more clarity to what was meant by social context in the past. And it's not changing the legislation, it's just putting more clarity into the usage of systematic racism and systemic discrimination. And I applaud him and will support him on this. Thank you.
Thank you, Mr. Battiste. Monsieur Fortin.
Merci, Madame.
Well, thank you, Madam Chair. 3 things. First of all, I just want to correct something. My colleague, Mr. Virani, talked about peremptory issues with the jury, and he said that there was systemic racism. And now I apologize, but that has nothing to do with this. When a lawyer recuses a jury, he or she believes that the jury is not adequate in the circumstances. Now, it could be for gender, race, it could be because of the professional training, judicial precedents, because the person had been victim of a crime. So there are a host of reasons why counsel will recuse a jury, and it has nothing to do with systemic racism. It's something completely different. So that's important to understand, because otherwise we're going down, moving in towards a dead end. No, so that's my first point. The second point, the bill that we're currently considering calls for judges to receive training on sexual assault. Now, for years, we've been talking about this. It dates back to Ms. Ambrose from the Conservative Party. She tabled it. The Bloc supported it. We still support this measure. But here we're introducing something. We're saying we're going to go a little bit farther. Not only are we going to give them training on sexual assault, we're also going to provide training on racism, on systemic discrimination. And we're going to add it that it's going to be systemic in nature. But now, that is taking us far away from the initial thing. It's like we go off to buy potatoes at the store and we come back with strawberries. It doesn't work. It's completely different. I don't think we can do that. So thirdly, if we're going to do a different bill, because what we had talked about was training on sexual assault, if we want something different on systemic discrimination, that's fine and well, but that can be something we can do. But we'll have to do another bill completely, or to reopen the witness list to hear from witnesses, as Mr. Moore said, because no one talked about systemic racism and discrimination. We're talking about training, continuing education on sexual assault, because victims of sexual assault are not always, well, how can I put it, considered with all of the due consideration they should receive based on the crime that they were a victim of. So that's what we're focusing on. That's what we want the judges to understand. So if someone is a victim of sexual assault and they're called to testify, we need to take into account the crime involved. Now, introducing racism here, well, this I'm not saying that it's not virtuous. Racism does exist. Yes, discrimination exists, but do we need to deal with it? Yes, but we can't mix that here into training, continuing education on sexual assault. We're going beyond the scope of this. So, and otherwise we're going to simply be reopening the debate. Otherwise we're going to have to bring here other witnesses, read through some briefs. I would have some witnesses to introduce and to bring forward if we want to bring this and extend it to these concepts of systemic racism and systemic discrimination. Thank you, Madam Chair.
Thank you, Mr. Fortin. I have Mr. Moore, and then I will call the question. Go ahead, Mr. Moore.
Thank you, Madam Chair. And addressing some of the comments made, I'm going to be supporting Mr. Fergus' amendment. The concern I have is it is important for us, I believe, in the future to, if we're going to be bringing in amendments, it's not just enough to hear witness testimonies on the generality of what we're trying to deal with, but it's important to hear on the specifics of the amendment. There's going to be a diverse groups that could comment specifically on amendments that are being proposed. And what the other parties have done is limit the witness testimony that we can have. So I would love to hear some testimony on this, but we're not going to do that. So, Madam Chair, I will make that point, and then we can carry on. But I did want to ask on the issue of admissibility of various amendments coming up. Will you be in advance advising us of your views on admissibility, or is that something that is done? I mean, normally that would be the case. I just want to check as we proceed whether you'd be advising us in advance whether various amendments are within the scope of the bill.
Thanks, Mr. Moore. So just for clarity, when it comes to whether something is within the scope, I do consult with our clerk and the legislative team with respect to whether something is procedurally within the scope of what is being proposed, and then also substantially, it is up to the person who is questioning the admissibility of a certain thing to make their argument, and I will make a ruling after the fact. And that is kind of how it's been worked out in the past in my conversations with the clerk as well. I hope that clarifies it for you. And so just going to the Lib 1, I will put it to a recorded vote, I assume, from everybody. Can I see thumbs if we want to do a recorded vote? Okay. So the question is, shall Lib 1 carry? Mr. Clerk, if you can please do the recorded vote by alphabetical order by member. Thank you.
Mr. Cooper?
In support.
Ms. Finley? Ms. Finley? Are you there, Ms. Finley?
Sorry, I couldn't hear you. Yes, I approve the amendment.
Monsieur Fortin?
Mr. Fortin?
Monsieur Fortin?
Je suis contre l'amendement.
I vote against the amendment.
McGregor?
I'm in support of the amendment.
Mr. Baptiste?
I support the amendment.
Mr. Lewis?
I support.
Mr. Maloney?
I'll support it.
Mr. Moore?
Support.
Mr. Sangha? Mr. Sangha, are you there?
Oh, sorry. Sorry, I support the amendment.
You vote in favor?
Yes, please.
Okay.
I vote in favor.
Mr. Virani?
I support the amendment.
And finally, Mr. Fergus.
Je vote en faveur de l'amendement.
I support the amendment.
Pour 10, 10 et nays contre 1, 1.
Thank you, Mr. Clerk. So the amendment carries. So moving on to then the whole clause, shall clause 1 as amended carry? Mr. Clerk, if you can record the vote, please.
Mr. Cooper?
Yes.
Ms. Finley?
Yes.
Monsieur Fortin? Monsieur Fortin?
Oui, excusez, oui, oui.
Mr. McGregor?
Yes.
Mr. Baptiste?
Yes.
Mr. Lewis?
Yes.
Mr. Maloney?
Point d'ordre, Monsieur le greffier.
Point of order, Mr. Clerk.
Madame la Présidente,
Can we please finish the vote first,
Well,
Mr.
I
Fortin, and I'll come-
didn't vote. I didn't vote for. I voted against it. I said yes because I said yes. I was there. I was looking for the mute button, but I vote. Considering what I said before about the amendment of Mr. Virani, Mr. Fergus, I vote against.
Duly noted, Mr. Clerk.
Okay, I think we were with Mr. Maloney.
I'm voting yes.
Mr. Moore?
Yes.
Mr. Sangha?
I vote yes.
Mr. Virani?
Yes.
And Mr. Fergus, Monsieur Fergus?
Oui, je vote pour.
I vote in favor.
Et nays contre, 1-1.
Thank you, Mr. Clerk. So clause 1 is carried. So now we move to clause 2, which has, we'll first go to PV1. So just to clarify for everybody, if PV1 is adopted, Lib2 cannot be moved. And that is, as stated in the House of Commons Procedure and Practice, that amendments should be proposed following the order of the text to be amended. Once a line of a clause has been amended by the committee, it cannot be further amended by a subsequent amendment, as a given line may be amended only once. So we'll go on to PV1.
Point of order.
Yes, Mr. Moore, was that you?
Yeah, it was. Are we voting in alphabetical order?
Yes.
So how is Fergus last to vote? Am I missing something?
Oh, I didn't even realize. Mr. Clerk?
Well, it's a good question. Fergus is last because he's replacing Mr. Zuberi, who is usually last. So if it's okay with the committee, usually with substitute, I will have them voting for the person they usually will be substituting for.
Thank you, Mr. Clerk. Is that okay with everybody, or should we do that's good? Mr. Moore, are you comfortable with that? Mr. Lewis?
Yeah, for sure. I just thought that's the way we did it, but now that makes sense. That's fine.
Very well. Thank you, Madam Chair. I'm sorry. I do believe either Mr. McGregor or Mr. Maloney actually voted before I did. And I think L comes before M. So if we could check that up, please.
The same logic that the clerk had provided, that these members are replacing the permanent members of the committee, and so they're voting in their specific order of their names and not their own.
Thank you, Madam Chair.
Thank you, Mr. Lewis. Mr. Virani, is this your hand is raised on this specific question?
No, on PV2.
Okay. So I will go to you, Mr. Virani, to talk to PV2. Sorry, PV1.
Yeah, I'm sorry, I meant PV1. But I think from my experience in the last parliament, whenever there is amendments being proposed by a party without official status, we usually proceeded on consent, unanimous consent, as to whether we would let that person speak to their amendment. So I know we afforded Ms. May that appropriate sort of gesture on many occasions in the last parliament. So I would propose that Ms. Atwin be able to speak to her own amendment.
Thank you, Mr. Virani. Do I have the consent of the committee to proceed with that? Yes. Mrs. Atwin, if you can please go ahead to speak to PV1.
Thank you very much, Madam Chair, and I wish to thank the committee today for allowing me the opportunity to speak. It's my first time proposing amendments and learning the whole process as well. So I'm certainly not here to slow anything down. I will be very brief. But I also wish to say I do not come from a legal background, rather education, but in either case, context is everything. And it's very important to me that we get this bill right, because I think it's a wonderful initiative on behalf of members of Parliament. So within the amendment, I speak about social context and expanding that to include, as we understand, a variety of subjects, but we deem that it's essential that the preamble clearly state that it's essential to understand the intersection of systemic oppression and gender identity and the dynamic it plays in the perpetuation of sexual violence. So the specific there is on the inclusion of systemic oppression in relation to gender identity. And of course, these amendments that I proposed are similar to ones proposed by the Black Caucus, Indigenous Caucus, and I wish to support their work and in no way undermine or overlap. So I think I'll leave it at that. Thank you very much.
Thank you, Mrs. Atwin. I have Mr. Virani next, but just before I go to you, Mr. Virani, PV1 amends clause 2, page 2, line 28. And if so, I'll go to you, Mr. Virani.
Sure, and I thank Ms. Atwin for her participation in the first ever virtual clause by clause as we sort of muddle our way through it in this parliament. I think these are important suggestions that are being made by the Green Party through Ms. Atwin. And what I would reiterate is that from my perspective and many of my Liberal colleagues, we are very keen on ensuring that the language that talks about social context covers off and clarifies what social context is meant to include. And that, from our perspective, is systemic racism and systemic discrimination. There are other Liberal amendments that follow this that refer to those concepts with exactly that language. And that was very deliberate in terms of drafting, and it was meant to be as encompassing as possible without going down the path of enumerating certain concepts, classes, or groups or demographics, which could open us up to the possibility of having unwittingly or inadvertently excluded some. So rather than enumerate specific categories, what we elected to try and do through some drafting creativity is just entrench concepts such as systemic racism and systemic discrimination, which would hopefully be large enough to encompass many of the things that are being proposed by many parliamentarians, including by Ms. Atwin. So it is on that basis that my support would be in favor of Lib 2 rather than it being in favor of PV1. So I will be voting against PV1. Thank you very much for the floor, and thank you, Ms. Atwin, for this helpful suggestion.
Thank you, Mr. Virani. I don't see any more members on the speaking list. Mr. Moore.
Sorry, Chair. Just to be clear, you've already raised the conflict between PV1, or Green 1, and Liberal 2, which those are mutually exclusive amendments. They can't both pass. What about NDP 1? Do you have a ruling on that?
So my understanding is that NDP 1 does not conflict with the specific lines that are proposed to be amended by PV 1 or Lib 2, and therefore it stands. But I will defer to Mr. Clerk to confirm if that's correct.
Yes, it is.
Thank you. So if that answers your question, Mr. Moore, I'll go to Mr. Virani and then Mr. McGregor.
Well, it actually doesn't, Madam Chair. I mean, to me, we have two definitions here of social context. It's using different words. It's making a muddle of this legislation. Liberal 2 says social context, which includes systemic racism and systemic discrimination. NDP 1 adds social context means the social factors that contribute to systemic inequality in Canadian society, including colonialism, systemic racism, ableism, classism, homophobia, and transphobia. It doesn't include systemic discrimination. It doesn't seem that that makes any sense, and that the two would be mutually exclusive.
Give me 1 second as I speak to my clerk about this and just clarify what you're saying, Mr. Moore.
And I want to be clear on it because how we treat those impacts how we treat Green 1, because we can't consider them one at a time. We have to consider them together because we're not going to adopt all of them.
Mr. Clerk, if I can ask you for reference, please.
I'm just going to look at we are in PV2. PV2 indicates, which includes, so it's not limitative to the list that follows. So it includes the list plus whatever needs to be added to the list. Same for lib2, indicates social assault law and social context, which includes systemic racism and systemic discrimination. And then that could possibly be understood that it includes, but it's not excluding of what's proposed by NDP2. If the committee wanted to have a more comprehensive definition, I could suggest that they'll do it in NDP 1, put aside PV1 and Lib 2 and try to come to an agreement on what the definition could be. But that's up to the committee to decide. The way we see it is not that they are exclusive of each other, the three of them. But if there is a will to have a definition at one place of the bill, that's up to the committee to decide.
Okay, thank you for that. In that case, and just taking the advice of the experts here, is it the will of the committee to go to NDP 1 before we discuss PV 1 and then Lib 2? I see Mr. McGregor, your hand is raised.
Yeah, thank you, Chair. And I take Mr. Moore's point. That's the problem when we all submit amendments at once and we try and figure our way through these. In the interest, I take what Mr. Virani argued before. If we start making a list of all of the different types of discrimination that can exist in our society, we run into the very real danger of excluding some. And so in the interest of keeping this bill, when we report it back to the House, with some continuity and some consistency, I will ask the committee for unanimous consent to withdraw NDP 1 and just proceed with the existing amendments that we have before us.
Thank you, Mr. McGregor. Is there unanimous consent of the committee? Monsieur Fortin? You just need to either raise your hand or a thumbs up, please. I am going to assume that if he's not intervening, that he consents. Is everybody okay with that? Okay, wonderful. Thank you very much for that, Mr. McGregor. We'll go on to PV1. Mr. Virani, is this something, are you trying to speak to PV1 at this time?
No.
Okay.
I think we should call the question.
Thank you. I appreciate that. So calling the question on PV1, the question be, shall PV1 carry? Mr. Clerk, if you can please call the vote, record the vote on PV1.
Thank you, Madam Chair. So let's go now with Mr. Cooper.
Against.
Mr. Bragdon, who I think is replacing Ms. Findlay now.
That's correct. Against.
Monsieur Fortin? Monsieur Fortin contre. Mr. McGregor?
Against.
Mr. Baptiste?
Against.
Mr. Lewis?
Against.
Against. Thank you. Mr. Maloney?
Against.
Mr. Moore?
Against.
Mr. Sangha?
You're on mute, Mr. Sangha.
Against, please.
Mr. Virani?
Against.
And finally, Mr. Fergus.
Je suis contre.
I vote against.
It's yeas pour, 0, 0, and nays contre, 11, 11.
Thank you, Mr. Clerk. And so PV1 is defeated. Moving on to Lib 2. Mr. McGregor, is that you forgotten to lower your hands? Yes, okay. Mr. Virani, you're next. I see your hand. To speak to Lib 2?
I just forgotten to lower it. I apologize, Madam
Okay.
Chair. I believe it was moved by Mr. Fergus.
Thank you. Thank you for that, Mr. Virani. Mr. Fergus, can you talk to Lib 2, please?
Oui, Madame la Présidente, c'est
Well, yes, Madam Chair, this is similar to the justifications that I made for Lib 1. It's to be consistent with the wording and to acknowledge, and I think Mr. McGregor generously did what he did. In this case, we have a non-exclusive category as opposed to having a very specific list that excludes items not mentioned. So that's the reason why I've used the same wording: systemic racism, systemic discrimination, as part of this amendment. Thank you, Madam Chair.
Thank you for that, Mr. Fergus. Mr. Fortin, I see your hand raised to speak to Lib 2.
Oui, Madame la Présidente.
The interpreter cannot hear Mr. Fortin.
Please move your microphone down
Sorry,
so the
okay.
interpreter can hear you. Thank you.
Yeah, j'ai écouté l'intervention.
Well, I listened to Mr. Fergus. Along the same lines, I'm opposed to this because it has nothing to do with this. Now, Madam Chair, I'm wondering if I shouldn't raise a point of order on this, if we shouldn't have a point of order, because this is a bill about giving information to judges on sexual assault. Now, this is information on judges to judges on racism, discrimination, oppression, systemic racism. Well, look, judges have training on a number of topics. We're not talking about judicial training here. We're talking about the specific issues surrounding victims of sexual assault. This is off topic. It has nothing to do with what was out of order to my mind. It's beyond the scope. And I don't think that we can address this here at the committee without having heard witnesses on the issue, without having, well, at any rate, I'm opposed to this for those reasons. Thank you, Madam Chair.
Thank you, Mr.
Et j'ajouterais que je nous invite à la...
And I'd like to invite us all to be very cautious. We need to be careful with respect to what we're doing. Now, everyone loves apple pie. That's not the issue here. But that's not what we're discussing here in this bill.
Thank you, Monsieur Fortin, for raising your concerns. Just for clarity's sake, the bill before us also speaks to social context. And my understanding is that these amendments that are being proposed are seeking to further clarify what social context is, and therefore are within the scope of what this bill is proposing. Thank you, Monsieur Fortin. I don't see any more hands raised to speak to Lib 2, so I will call the question. Shall Lib 2 carry? Mr. Clerk, if you could please administer the recorded vote.
Mr. Cooper?
In support.
Mr. Bragdon? Mr. Bragdon?
In support. In support.
In support. Monsieur Fortin?
Je suis contre.
I vote against.
Contre. Mr. McGregor?
I support the amendment.
Mr. Baptiste?
I support the amendment.
Mr. Lewis?
Support.
Mr. Maloney?
Support.
Mr. Moore?
Yes.
Mr. Sanga?
Support.
Mr. Virani?
Support.
Et finalement, Monsieur Fergus.
And finally, Mr. Fergus, I support.
So, yeas pour, 10-10, nays contre, 1-1.
Thank you for that, Mr. Clerk. And so Lib 2 is carried. NDP 1 was withdrawn. And at this time, Mr. Clerk, I will stop to ask if we are approaching the amendments that Monsieur Fortin had emailed earlier. If I can seek clarity from you on that, please.
Oui, Madame la Présidente, c'est à moi que vous avez donné la parole,
sorry.
je pense. Hein?
Sorry, Mr. Fortin, I'm just seeking some clarity from our clerk as to whether we'll be going to you first or PV2 first.
We should go to Mr. Fortin's amendment, but if I'm correct, I think Mr. Maloney had some amendment that would go there as well before PV2.
Mr. Maloney or Mr. Fortin, are they?
Madam Chair, I believe my amendment is identical to the one Mr. Fortin is proposing, so I'll let him go ahead.
Okay. Thank you. Thank you, Mr. Maloney. Monsieur Fortin, please go ahead to speak to your amendments. If you could please read out the language so that everybody's following.
Before I go to my amendment, I'd just like to make sure now. I understand Lib 1 was adopted, but PV 1 went with Lib 2. PV 1 was rejected then, if I'm not mistaken. Was it not? So then we should be on Lib 2 now then.
On Lib 2, Monsieur Fortin, we're now on, so we voted and Lib 2 carried. So you voted against Lib 2 just now as well.
C'était mon intention. Vous me rassurez.
Well, good thing, because that's what I planned to do. So I didn't vote on PV1 then.
Voted on everything.
OK, alors, parfait. Donc, on serait rendu à NPD 1 ou à le premier de mes amendements.
So we should be on NDP 1 or my amendment then, the 2.1.
Oui.
NDP 1 was withdrawn by Mr. McGregor. Oh. So we are now looking at your amendment that you had emailed to everybody at the beginning of this meeting today.
OK. Alors, c'est mon amendement concernait.
So it's my amendment then. It's clause 2. 2.2, which amends that section of the Act. What it said was, the Council shall ensure that seminars on matters related to sexual assault established under paragraph 2B, and so I replaced shall with should. And the changes that I have put forth are changes that come from justices. The one from Nova Scotia, I can't find his name here, but 2 judges appeared during the hearings, and they invited us to be cautious in the actual wording, to not be too directive or prescriptive, and to invite them, if I can put it that way. So I think that it would be a good idea to adopt it that way. So instead of the Council shall ensure, the Council should ensure.
Thank you, Monsieur Fortin. I'm just going to quickly turn to Philippe to guide us on what the impact of these amendments would be, and also to see if they're in order.
I won't comment on the impact. That would be more of a legalese question that the department may weigh on it. As far as procedural admissibility, they're fine.
They're fine.
Thank you.
Thank you. Thank you for that. I don't see Mr. Maloney. I see your hand raised.
Thank you, Chair. I support the amendment Mr. Fortin has proposed and agree with everything he has said. One of the things that we need to consider in the back of our minds in every amendment we're discussing today is the concept of judicial independence. And this amendment that Mr. Fortin has proposed, as he pointed out, which was we were encouraged to do so by the Canadian Judicial Council and other representative groups, is this goes some way to preserving that very important concept. So I agree with him wholeheartedly.
Thank you very much. Not seeing any more hands raised, I'll call the question. Shall the amendment moved by Mr. Fortin, which seeks to amend Clause 2 on page 2, line 32, replacing the council shall with the council should ensure that seminars on matters. So, Mr. Clerk, I'll ask you to please record the vote.
Thank you, Madam Chair. Mr. Cooper?
In support.
Mr. Bragdon?
In support.
Monsieur Fortin?
Pour.
In support.
Mr. McGregor?
Against.
Mr. Baptiste?
I vote in favor.
Mr. Lewis? Mr. Lewis?
I support.
Thank you. Mr. Maloney?
I'm in favor.
Mr. Moore?
Yes.
Mr. Sangha?
I'm in favor.
Mr. Virani?
Yes.
Et puis finalement, Monsieur Fergus.
And finally, Mr. Fergus, in favor.
La présidente, yeas pour 11, 11 et nays contre 0.
Thank you for that, Mr. Clerk. So the amendment proposed by Monsieur Fortin carries. Thank you. Now we move on to PV2. I'll turn to Mrs. Atwin to speak to PV2 at this time, please.
Thank you again, Madam Chair. So this amendment would propose a change to include persons, groups, and organizations that support them, including Indigenous leaders and representatives of Indigenous communities. We cannot ignore the prevalence of sexual violence and its impacts on Indigenous, Métis, and Inuit women. We believe it essential that the section explicitly mention the need for involvement of Indigenous leaders and representatives in development of these seminars. This proposed amendment is also consistent with the spirit of the calls to action emanating from the Truth and Reconciliation Commission and the report from the Inquiry into Missing and Murdered Indigenous Women and Girls. So once again, I do not wish to hold things up in any way, and I appreciate your consideration of this. Thank you.
Thank you. I don't see any hands raised to speak to PV2, so I'll call the question. Shall PV2 carry? Mr. Clerk, if you can please record the vote.
Mr. Cooper?
In support.
Mr. Bragdon?
In support.
Monsieur Fortin? Monsieur Fortin?
M'avez-vous appelé?
Oui.
Did you call me? Oh, sorry. I vote in favor. Mr. Fortin?
2.
Mr. McGregor?
Yes, I vote in favor.
Mr. Baptiste? Mr.
I vote
Baptiste?
against.
Against?
I vote against.
Mr. Lewis?
I vote for.
Mr. Maloney?
I'll vote against.
Mr. Moore?
In favor.
Mr. Sangha?
I vote against.
Mr. Virani?
Against.
Et puis, Monsieur Fergus?
Contre.
Fergus opposed.
So, yeas pour 6, 6, et nays contre 5, 5.
So with that vote, PV2 is carried. We'll now go to PV3. Mrs. Atwin, if you'd like to speak to PV3.
Considering it's the similar amendment that was already voted down, it does include the concept of gender identity. I still wish to be on the record for advocating for this to be included. So thank you very much for your time.
Thank you. I see the hand raised from the legislative clerk.
Sorry, I think Mr. Fortin has an amendment just before the amendment to PV3.
Before PV3, yes, you are right. Thank you for that. Mr. Virani, is that what you had? Is there a specific, you have your hand raised, are you speaking to anything specific?
No, it was to speak to the amendment that is put forward as PV 2 or 3 at this point, but I'll defer to the clerk.
Thank you, Mr. Virani. So we are correct. We are now moving to an amendment from the floor by Monsieur Fortin, which seeks to amend Clause 2, page 3, line 3. And it seeks to add where the council find appropriate. Mr. Fortin, if you want to speak to that, please.
Alors, ça va dans le même sens.
Well, it's like what I said earlier, Madam Chair. The idea is to preserve judicial independence and not to be too directive. It speaks for itself. I don't need to say much more about it. I would propose where the council finds appropriate. Thank you.
Si vous avez des questions, je vais y répondre.
Of course, if you have any questions, I'd be happy to answer them, but I don't want to take any time to explain it.
Thank you, Mr. Fortin. I see Mr. Maloney, your hand is raised.
Mr. Fortin said virtually the same thing I was going to, so I'm fully in support. This amendment is consistent with the amendment we just adopted, which he put forward a minute ago for the reasons that he explained. Thank you.
Thank you, Mr. Maloney. I don't see any more hands raised, so I'll call the question. Shall the amendment proposed by Mr. Fortin carry? Mr. Clerk, if you can please record the vote.
Avec plaisir, Madame la Présidente. Alors, Monsieur Cooper.
In support.
Mr. Bragdon.
In support.
Monsieur Fortin.
Pour.
Mr.
In favor.
Against.
Mr. Baptiste. Mr. Baptiste.
Favor. In favor.
In favor. Mr. Lewis.
In support.
Mr. Maloney.
I support it.
Mr. Moore.
Support.
Mr. Sanga.
I support.
Mr. Virani.
Support.
Et puis Monsieur Fergus.
Je suis en faveur.
Mr. Fergus, in favor.
So, yeas pour 10, 10, et nays contre 1, 1.
Thank you, Mr. Clerk. And so the amendment as proposed by Monsieur Fortin is carried. We now move to PV3. Mrs. Atwin, if you'd like to speak to PV3.
Thank you once again, Madam Chair. And just in relation to social context, which includes systemic racism and systemic discrimination, including seminars established, I ask that it include systemic oppression and gender identity as the dynamic it plays in the perpetuation of sexual violence. Thank you.
Thank you, Mrs. Atwin. I don't see any hands raised to speak to, Mr. Virani?
Yes, Madam Chair, I appreciate Ms. Atwin's involvement here. In terms of this specific sort of enumeration in terms of what she's listed here, I think I'd raise a few points. One is that the seminars in question relate specifically to the sexual assault seminars provision of the bill. I think it's important that we have the legislation and the flexibility that's provided to the judges in order to shape the seminars as they see fit. And introducing this kind of language, I think, would not be appropriate in this context. It's also pretty apparent that various different provinces approach this with different resources and with different approaches. And given that a lot of these eventual adjudication will occur at the provincial bench, that is something that we should keep in mind. So leaving it open, I think, would be more prudent than enumerating this particular language in this context. Thank you.
Thank you, Mr. Virani. Not seeing any more hands raised, I'll call the question. Shall PV3 carry? Mr. Clerk, if you can please record. Oh, Mr. Fortin. Oh, no. Okay. Mr. Clerk, if you can please go ahead and record the vote.
Mr. Cooper?
Against.
Mr. Bragdon?
Against.
Monsieur Fortin?
Mr. Fortin?
Monsieur Fortin?
Contre.
Contre?
Fortin contre.
I think that was me. Against.
Mr. Baptiste?
Against.
Mr. Lewis?
I vote against.
Mr. Maloney?
Against.
Mr. Moore?
Against.
Mr. Sanga?
Against.
Mr. Virani?
I am against.
And Mr. Fergus?
Je suis contre.
I'm against.
0, 0. Et nays contre, 11, 11.
Thank you, Mr. Clerk. And so PV3 stands defeated. So not seeing any more amendments to Clause 2, we'll now vote on Clause 2. So I ask, shall Clause 2 as amended carry? Mr. Clerk, if you can please record the vote.
Mr. Cooper?
In support.
Mr. Bragdon?
In support.
Monsieur Fortin?
Ouais.
Malheureusement, je n'ai pas bien entendu, Monsieur Fortin. Est-ce que vous pourriez répéter, s'il vous plaît?
Oui. Ben, je vous ai pas entendu m'appeler, Monsieur le greffier. Je sais pas.
Well, I didn't hear you call me. I seem to be missing it, except on the second try. Maybe it's something to do with the delay or the. But I'm voting against this.
Monsieur Fortin contre. Mr. McGregor?
Yes, I support the clause as amended.
Mr. Baptiste?
I support.
Mr. Lewis?
I support.
Mr. Maloney?
Yes.
Mr. Moore?
Yes.
Mr. Sanga?
Yes, I support.
Mr. Virani?
I support.
Et Monsieur Fergus?
J'appuie la clause numéro 2.
I support.
Yeas pour, 10, 10, et nays contre, 1, 1.
Thank you, Mr. Clerk. And so Clause 2 carries. Now moving on to Clause 3. Before we go to Lib 3, my understanding is Monsieur Fortin's proposed amendment comes before in the order by line. So Mr. Fortin's amendment for Clause 3 seeks to amend page 3, line 11, and that is replacing shall with should on that line. Monsieur Fortin, the floor is yours to speak to your amendment.
Alors, ça va dans le même sens que tantôt, Madame la...
Well, similar to what I said earlier, we don't want to be directing the council to do something. We'll ask the minister to call upon the council to report. So it's in deference to judicial independence again here.
Thank you, Monsieur Fortin. Not seeing any hands raised to speak to this. Oh, Mr. Virani?
Just so I'm crystal clear, Madam Speaker, so the amendment would be just to that line, I guess it's line 11, but it now reads the council shall submit to the minister, and it would read instead the council should submit to the minister. That's what we're voting on, correct?
That is my understanding. Can I just get confirmation from the clerk on this, Philippe?
Yes, indeed, you're right.
Thank you for that. Mr. McGregor, did you want to speak to this also?
Yeah. Sorry, it was the same question. So it's just the replacing
just the
shall
one
with
word.
should.
Yeah.
Okay.
Thank you. So in that case, then I'll call the question.
Madame la Présidente, un petit point d'ordre, si vous permettez. Je réalise que dans la version...
A point of order, Madam Chair. I see that the English version isn't the same as the second one.
Alors qu'en français, on dit...
But on the French, it says the minister asks. So there are two versions in what I submitted are different. Now I can live with the English version. The council should submit it to the minister. So that's the version that my colleague, Mr. Varani, agreed with. And we had worked on that issue, so I agree with the English version, the council should.
Thank you, Monsieur Fortin. So just for clarity, Mr. Clerk, and to the analysts, if we can make that requisite translation into French to be just that changing of the shall to should. So I'll call the question at this time. So should the amendment proposed by Monsieur Fortin carry? And Mr. Clerk, I'll ask you to record the vote, please.
Mr. Cooper?
In support.
Mr. Bragdon?
In support.
Alors, voyons voir si ça fonctionne cette fois-ci, Monsieur.
Let's see if it works this time, Mr. Fortin.
Monsieur Fortin.
Mr. Fortin.
OK, pour.
In favor.
Mr. McGregor.
Against.
Mr. Baptiste.
I support it.
Mr. Lewis.
I support.
Mr. Maloney.
I support it.
Mr. Moore.
Support.
Mr. Sanga.
I support.
Mr. Virani.
Support.
Et puis Monsieur Fergus.
Mr. Fergus.
Pour 10, 10 et nays contre 1, 1.
Thank you, Mr. Clerk. And so the amendment proposed by Monsieur Fortin carries. We'll now go to Lib 3, which has been proposed by Mr. Baptiste. If I could please ask you to speak to it, Mr. Baptiste.
Thank you, Madam Chair. And I would just like to start off by saying that this amendment is very similar to that raised by my colleague, Greg Fergus, in terms of his advocacy on behalf of the Black Caucus. I very much appreciate, and in our deliberations between Black Caucus and Indigenous Caucus, there's an opportunity here with this amendment. And, we Canadians expect that judges have the necessary training to understand the complex nature of unconscious bias and how intercultural competency can impact judicial rulings, much like they expect judges to understand how myths around sexual assault and consent can. And while we all understand that justice is blind, it's no secret that racialized Canadians face systemic racism in our judicial system. And we need equally systemic solutions to change that. And education is key. Combating unconscious biases is something that was spoken to in the TRC calls to action, as well as the Murdered and Missing Indigenous Women's Group. And just a few days ago, the Globe and Mail published an in-depth investigation on Black and Indigenous Canadians in the justice system, where, according to the most recent census, Black people accounted for 4.8% and 3.5% of the Canadian population. According to the Statistics Canada, made up 25% and 8.7% of those in federal prisons. Ensuring that judges have training related to systematic racism and discrimination is important, and I think that Bill C-3 provides us an opportunity for jurisdictions to do their part in our country's effort to meet those said studies. And so I think that when we talked about social context, this is what I felt was Mr. Fergus's intervention and amendments gave clarity to what that social context is, and we have an opportunity with this community to take those important steps on reconciliation and our commitment to addressing systemic racism as well. And while respecting the original intent of the bill, but making it clear what is meant by social content. Thank you.
Thank you very much, Mr. Batiste. I don't see anybody on the speakers list, so I will call the question at this time. Shall Lib 3 carry? Mr. Clerk, if you can please record the vote.
Certainly. Mr. Cooper?
In support.
Mr. Bragdon?
In support.
Monsieur Fortin?
Non, je suis contre.
I vote against.
Mr. McGregor?
Yes, I support it.
Mr. Batiste?
In favor.
Mr. Lewis?
I support.
Mr. Maloney?
Yes.
Mr. Moore?
Support.
Mr. Sanga?
I support.
Mr. Virani?
Support.
Et puis Monsieur Fergus.
J'appuie cette.
Mr. Fergus, I support the motion.
Madam Chair, yeas pour 10, 10, et nays contre 1, 1.
Thank you, Mr. Clerk. And so Lib 3 is carried. So there are no, oh, so sorry, I have from the floor, Mr. Fortin seeks to amend clause 3, page 3, line 14 by replacing the word must in that line with the word should. Monsieur Fortin, would you like to speak to that? Monsieur Fortin?
Oui, ça va. En fait, dans la version...
Well, in the French, it talks about, it's different. The minister shall cause a copy of any report received. Mr. Fortin is on number 5, not number 4. So I'm not talking about... Yes?
Then just to seek clarity, you're talking about line 14 at this time, yes?
Là, je suis à la... Non.
No. Oh, should. Oops. Oh, it's the same thing as earlier then. It's replacing must with should. Sorry, I thought we were on the next one. So no, same comments.
Thank you. Mr. Virani, is your hand raised to speak on this?
Yes, it's effectively the same issue as before, because I'm not sure, and perhaps Monsieur Fortin or peut-être le greffier could assist us, but the change that's being asked for on the English side is very clear, but if they could just clarify the change that would then be made on the French side, because I don't see the directive language as clearly written en français, but it's not my langue maternelle, so maybe I'm just not reading it correctly. So if we could just make sure, maybe the clerk could advise us what language needs to be put inside on the French side to make it discretionary rather than directive. Merci.
Thank you, Mr. Virani. Mr. Clerk or the analyst, if you can.
Oui, Madame la Présidente. In the French version, there is no need to have a change to replace that should, the second should, because it's already included in the first one. Because in French we say dans lequel il précise, it's the report that we're talking about. In the one we are, in the one that is being submitted, in a loose translation of it, if you want.
Et c'est aussi ma compréhension.
And I confer that is my understanding as well. I confirm that.
Thank you. Thank you, Monsieur Fortin, and thank you, Mr. Clerk, for that clarity. So I will call the question now at this time for Monsieur Fortin's proposed amendment to amend Clause 3, page 3, line 14 to replace must with should in that line. Mr. Clerk, if you can please record the vote.
Mr. Cooper,
In support.
Mr. Bragdon,
In support.
Monsieur Fortin,
Pour.
In support.
Against.
Mr. Baptiste,
I support it.
Mr. Lewis,
In support.
Mr. Maloney,
I support it.
Mr. Moore,
Support.
Mr. Sanga,
I support.
Mr. Virani,
Support.
et puis Monsieur Fergus.
And Mr. Fergus.
J'appuie. Je suis en faveur.
I support it.
10, 10, nays contre, 1, 1.
Thank you.
Merci au greffier.
Sorry, did somebody just speak? Oh. Thank you, Mr. Clerk. So the amendment as proposed by Monsieur Fortin is carried. Monsieur Fortin, you have the next amendment as well that comes to you to discuss before we go to vote on the whole clause. So your next amendment, my understanding, is clause 3, page 3, line 20. You had inadvertently spoken to it earlier, so I'll ask you to continue. What you're proposing is to replace the word the with any in the context of speaking about a report. So go ahead, Monsieur Fortin.
Merci, Madame la Présidente. En fait,
Thank you, Madam Chair. The French version is fine. It was the English version that I felt there could be some confusion, and I had some discussions with Mr. Virani earlier to clarify. And so the idea was that if there is a report tabled, then the minister needs to table that report. So the French version is fine, but now my English isn't as good as his, but my honorable colleagues, but the idea is that it's if any report is received or tabled, then it needs to be tabled in the House.
Thank you. I see the legislative clerk's hand is up.
Yes, thank you, Madam Chair. Just to understand exactly how the that paragraph 2 would read after the amendment. So I'm just going to read it to make sure I understand it properly. So it would be tabling a report, paragraph 2, the minister shall cause a copy of any report received to be tabled in each House of Parliament on any of the first 10 days on which that House is sitting after the minister receives the report. Is that correct?
That is my understanding. Monsieur Fortin, can you confirm that, please? Yes.
Je confirme, c'est également ce que j'en...
Yes, yeah, that's my understanding as well. And that's the idea behind it, yes.
Merci,
Thank
Monsieur
you very
Fortin.
much. So in that, I don't see anybody else wanting to speak to it, so I'll call the question on Monsieur Fortin's amendment. Mr. Clerk, if you would like to record the vote, please.
Mr. Cooper,
In support.
Mr. Bragdon,
Support.
Monsieur Fortin,
Mr. Fortin. Mr. Fortin? It's my turn. Yes, in favor.
Support.
Mr. Baptiste,
I support it.
Mr. Lewis,
In support.
Mr. Maloney,
I support it.
Mr. Moore,
Support.
Mr. Sanga,
I support.
Mr. Virani,
I support.
and Monsieur Fergus.
And Mr. Fergus, I'm in favor.
11, 11, nays contre, 0, 0.
Thank you, Mr. Clerk. And so the amendment proposed by Monsieur Fortin carries. So now I call the question on clause 3. Shall call clause 3 as amended carry? Mr. Clerk, if you could please record the vote.
Mr. Cooper,
In support.
Mr. Bragdon,
In support.
Monsieur Fortin,
Mr. Fortin? It's my turn, yes?
Je sais pas. Est-ce que c'est à mon tour là, de voter?
So it's my turn to vote? Okay, well, I have to vote against this one, given the amendment on discrimination and systemic racism.
Mr. McGregor?
Yes, clause 3 is amended. I support it.
Mr. Baptiste?
In support.
Mr. Lewis?
I'm in support.
Mr. Maloney?
I support it.
Mr. Moore?
Support.
Mr. Sangha?
I support.
Mr. Virani?
I support.
Et puis Monsieur Fergus?
Je suis en faveur.
Mr. Fergus in favor.
Pour 10, 10, et nays contre 1, 1.
Thank you, Mr. Clerk. And so clause 3 carries. So we have a limited time left as we go into the last bits of the clauses. And I ask the committee if it's okay with everybody that we carry on a little bit further so that we can get through the complete clause by clause for Bill C3. We'll see. Thank you. I see thumbs up. I appreciate that. So going into clause 4, we have NDP 2, which is being proposed. Mr. McGregor, if you would like to speak to that, and anybody else who'd like to speak to it can raise their hands also. Go ahead, Mr. McGregor.
Yes, thank you, Chair. Just a slight change here to line 8 on page 4 of the bill. And this comes from the testimony of Ms. Roselle Kim, who's the staff lawyer at the Women's Legal Education and Action Fund. In her opening statement, she had talked specifically about Clause 4 as it relates to the reasons, and she suggested directly in her opening statement that where written reasons are not available in a sexual assault trial, the transcripts of the decision only and not a transcript of the entire trial should be available on publicly accessible domains. So just following her recommendation, I have decided to come up with an amendment to that final line to change it to provided in writing and made publicly available.
Thank you, Mr. McGregor. Ms. Demoff, unless Mr. Virani, your hand is not up by error. Did you want to speak? Ms. Demoff, the floor is yours.
Thank you, Chair. And I really appreciate being able to speak to this at committee. I was the former vice chair of the Status of Women Committee when we studied Bill 337 when it came to Parliament before. And you know, that bill, I've got a signed copy of it in my office. And I want to give a shout out to Ms. Ambrose and to the members of the Status of Women Committee, because we really did do a lot of work collaboratively across party lines. And this was actually an issue that we discussed at length, whether or not to include written reasons. And we actually, when the bill first came to us, we actually amended it to say that that reasons, if they were not recorded, that they should be provided in writing. And I just wondered, Chair, if I could read some of the submissions that we received in April 2017. Justice Kent, who I know appeared before the Justice Committee, but in 2017, she said, if it allows for audio recordings to be available, that makes a lot more sense. We had this Office of the Federal Ombudsman for the Victims of Crime in 2017 saying, ensuring that new legislation does not cause further delays in the criminal justice system is important, something that should be considered with respect to the requirement for a written decision. And then finally, in a submission from the Native Women's Association in 2017, they said, and I'm quoting them, while justice needs to be served as expeditiously as possible, judges should not unreasonably extend the incarceration of Aboriginal offenders while they await conclusion of trials due to the necessity of written reasons. Generally, Aboriginal offenders fail to be granted bail and are left incarcerated during the trials. So, Madam Chair, the Supreme Court in Jordan set time limits for the courts to give their decisions. And so while the spirit behind the members' amendment is worthy, and one that I know caused us a great deal of discussion when we were at Status of Women Committee. At the end of the day, I think it puts an undue burden on the judiciary and in fact could have a negative impact for survivors of sexual assault who want to see the reasons. The recordings are available, and that was a concession that we made previously to ensure that there was something available for survivors to be able to have access to. So I just wanted to give that context, and while I can't vote, I would not be supporting that if I had the ability to, because I think it isn't the right thing to be doing. So thank you, Madam Chair.
Thank you so much for that, Ms. Demoff, and thank you for all of your efforts for over the past number of years on this very important topic. Thank you. Mr. Moore, I have you next on the list.
Thanks, Madam Chair, and thanks to Mr. McGregor for bringing this forward. I not to put them on the spot, but I know we have lawyers here from the Department of Justice. Can we get, is there anything that unintended consequence perhaps of this amendment, any flags that this amendment would raise in the administration of justice?
I will turn to our witnesses. If you can please respond to Mr. Moore's inquiry.
Thank you. Can you hear me? Yes. Well, this certainly is a well-intended proposal. The thing is that it might not really be necessary, given that the open court principle is already a fundamental principle in the Canadian criminal justice system, in fact, in the justice system as a whole. And that is already covered by the ability to attend and to have access to reasons, which is part of the changes in this particular bill, including that the reasons be on the record or written. So that including made publicly available is a form of codifying the open court principle, which is not necessary and in fact could cause some confusion given the maxim that the legislator does not speak in vain. So it could, as a result, give interpretation that its exclusion elsewhere in the code means that the principle does not necessarily apply in other contexts. In addition, the requirement for the written for reasons relates directly to the federal head of power in terms of the criminal law, as these reasons are necessary for the purposes of appeal. However, it's quite different to then move into an issue of how these reasons become publicly accessible, which is a matter of administration of justice, which falls within the jurisdictions of the provinces and territories. So it may be straying beyond federal jurisdiction to some degree. Thank you.
Thank you.
Thank you very much for that, Ms. Blackwell. I have Mr. Virani next on the list.
I just wanted to reiterate some of the points that Ms. Damoff made, and also the points just made by the department officials, which were very helpful. But to my mind, the open court principle is sufficient to address this baseline proposition about the accessibility of the reasons, and the actual text of the statute itself, as it's currently of the bill as it's currently drafted, indicates where the matter is not an open proceeding, that where there is no record, that the reasons would need to be provided in writing. So my view would be to oppose this well-intended idea and to stick with the current bill in its current format. Thank you.
Thank you, Mr. Virani. Mr. McGregor, if you can speak to it, and then I'll call the question. You're on mute, Mr. McGregor, sorry.
Maybe just a question to our legislative officials. When Ms. Kim was suggesting this, she said that as the bill currently stands, any oral judgment entered into the record will still require someone to pay for and order the trial transcript, which is costly and can be time-consuming. Are officials able to speak to the point she made there? Because what she was stating in her opening statement seems to go against the open court concept, the fact that some people still have a monetary burden in accessing these records.
Thank you, Mr. McGregor. Ms. Blackwell, I turn to you if you'd like to speak to that.
Yes, thank you. Well, this is true that the courts have different ways in which they make their information available. Most judgments will be posted either on the court websites or through CanLII, which is a free, accessible web-based database with Canadian judgments on it. However, short of an actual decision, and not all decisions will necessarily be published, the courts can make their reasons and as well other aspects of the court record available either through the courthouse, the court registry office. And how the courts do this is really within their jurisdiction, and they vary. Some have a fair bit available free, others use services for transcribing the testimony. So those are the transcripts may be costly depending on the services available. But this is not a matter for the federal Parliament in this particular context. That's really a matter for administration of justice. And certainly I think courts are aware and do their best to try to make as much available as possible, but there are costs associated at times in doing so.
Thank you so much for that, Ms. Blackwell. Having exhausted the speakers list, I'll call the question on NDP 2. Shall NDP 2 carry? Mr. Clerk, if you can please record the vote.
Mr. Cooper?
Against.
Mr. Bragdon?
Against.
Monsieur Fortin?
Contre.
Against.
Gregor?
For.
Mr. Baptiste?
Against.
Mr. Lewis?
I vote against.
Mr. Maloney?
Against.
Mr. Moore?
Against.
Mr. Sangha?
Against.
Mr. Virani?
Against.
Et puis Monsieur Fergus?
Mr. Fergus, against.
10? No, sorry. Yes pour 1, et puis nays contre 10, 10.
Thank you very much, Mr. Clerk. And so NDP 2 is defeated. The question is now on Clause 4. Shall Clause 4 carry? Because there were no amendments to Clause 4 at this time. So shall Clause 4 carry? Mr. Clerk, if you can please record the vote.
Mr. Cooper?
Yes.
Mr. Bragdon?
Yes.
Monsieur Fortin?
Pour.
In favor.
Yes.
Mr. Baptiste?
Sorry, what are we? I'm lost here. Can you give me a sense of
We're voting on Clause 4.
Okay, not the amendment. In favor.
In favor? Mr. Lewis?
I vote for.
Mr. Maloney?
Yes.
Mr. Moore? Mr. Moore?
You're on mute, Mr. Moore.
Yes.
Yes. Okay. Mr. Sangha?
Vote in favor.
Mr. Virani?
I vote in favor.
Monsieur Fergus?
Je suis en faveur.
I vote in favor.
11, 11, nays contre, 0, 0.
Thank you, Mr. Clerk. And so Clause 4 carries. Now I have one amendment, PV4, that is for the preamble, that's where we're moving to next. However, because PV1 was defeated, PV4 is inadmissible as no amendment to the bill, as there is no amendment to the bill to justify amending the preamble. And so we will not be going towards PV4 because it is at this time inadmissible. So shall the preamble carry. Mr. Clerk, if you'd like to record the vote, please.
Mr. Cooper?
Yes.
Mr. Bragdon?
Yes.
Monsieur Fortin? Monsieur Fortin, êtes-vous là?
Just give us a...
Oui, désolé.
Yes. Sorry, yes.
Yes to the preamble.
Mr. Baptiste?
Yes.
Mr. Lewis?
I vote in favor.
Mr. Maloney?
Sure.
Mr. Moore?
Yeah.
Mr. Sangha?
Yes, I vote in favor, please.
Mr. Virani?
Yes, I vote in favor.
Et puis Monsieur Fergus?
Mr. Fergus? I vote in favor.
11, 11, nays contre, 0, 0.
Thank you very much for that, Mr. Clerk. And so the preamble carries. Shall the title carry? Do we have unanimous for
Agreed.
title? Yes? Okay, wonderful. The title is carried. Shall the bill as amended carry?
Agreed.
Agreement?
Agreed.
Wonderful. Shall the chair report the bill as amended to the House?
Agreed.
We're in
Yes.
agreement?
Agreed.
Thank you. And shall the committee order a reprint of the bill as amended for the use of the House at report stage?
Agreed.
Agreed.
It should.
Wonderful. Wonderful. Congratulations, committee. We have now gone through our first hybrid clause by clause. You guys have been wonderful. I really appreciate that. So just before we adjourn, a few quick things. The witness list for C7, as discussed in our steering committee, is due today. So just make note of that to be sent to the clerk. Next week, we'll be having the minister appear on mains and subs, as we had agreed to at the beginning of this meeting. And so if there's no other committee business,
Sorry, Madam Chair, I believe it's this week, this Thursday,
this week,
right?
yes, this
Yes.
coming Thursday. So the next meeting. And so if there's no other committee business, meeting is adjourned.